This is Chapter 5, the Employment Contract. So we'll be talking about contract law, but mostly related to employment relationships. And as we already know, an employment relationship is based out of a contract. This contract may be in writing or verbal, preferably in writing. So the objectives for this chapter, even though it's written 4 there, but it's 5, we'll look at the requirements for a valid employment contract, and then understand some of the advantages of a written contract, identify common contractual terms, sections, and understand why they must be clearly drafted. We will not be looking at each and every clause or section, but some of the most important ones. And then we'll also look at understanding factors that affect the interpretation and also enforceability of the employment contract. So whether the employment contract can be enforceable, in other words, has legal effects, and also how courts interpret those contracts in case of ambiguity, in case of doubts, or misunderstanding by the parties. And some of those factors, they include the inequality of bargaining power, failure to meet some statutory standards, and obsolescence. So this word is difficult for me to pronounce, so I had to train a little bit here. So obsolescence. Okay. So let's start. Some principles in order to form a contract, to establish a contract, but also to modify an employment contract. Well, a contract will be formed, and this is a very brief explanation because if we were to study contract law, we could spend a full term just on contract. But briefly speaking, a contract will be formed when there's an offer and when that offer is accepted, and also when there's consideration. And I'll explain what consideration is. Consideration is mutual benefits. So both parties to a contract, they need to derive a benefit from that agreement, from that relationship. So if you buy coffee, so you are paying for coffee, the coffee seller is getting the money, the turnover, and you are getting the coffee. So this is an example of consideration. Both parties have to derive a benefit, because if they do not, it will be a gratuitous promise, it will be a free promise, then we'll see that the contract is not enforceable. But we'll see more details later. So again, there has to be an offer, and then that offer has to be accepted, and both parties have to derive a benefit from that contract. A contract, as I already said, may be verbal or in writing. It is highly recommended that it is in writing for evidence purpose, but a verbal agreement is as valid as a written one. Some specific types of agreement, the law requires them to be in writing, but they are the exception. For us in employment law, the exception is apprenticeship agreements. Those have to be in writing. Verbal ones are not valid. The offer has to be firm and unequivocal. In other words, it has to be clear with express terms, and it has to be a firm one. So it has to be communicated. You cannot say you are thinking about making an offer. If you say this, you are actually thinking. It is not an offer. So you have to actually make an offer. And in employment relationships, in most cases, the offer is in writing. And that offer can be subject to a condition We call this a condition precedent. Precedent because it is prior to the offer being accepted. That condition precedent, examples here will be a job offer as long as you successfully pass the background check. So that's a condition until a background check is performed and you successfully pass it. That offer is not valid yet. So when you have a conditional offer, it means this condition has to be met prior to the offer being valid, prior to the offer being able to be accepted. Okay? And when such a condition is there, both parties have to act in good faith to meet, to fulfill that condition. And by the way, we can add here one more. Oh, yes. And then when there's this unequivocal and unconditional acceptance, and when there's also evidence of consideration, so when parties benefit, both parties benefit from that contract, so the contract is formed. The contract is now valid. And taking the L, okay, learning. So a contract to be formed requires the offer to be accepted in an unconditional way. In other words, you accepting the offer, you cannot put conditions on the offer. The offer may have conditions, as we just saw, condition precedent. But you, the person accepting the offer, cannot put conditions, cannot change the offer. Because if that is done, we have a counter offer and not an offer. And what is a counter offer, legally speaking? A counter offer is actually the rejection of the offer, of the original offer, and the making of a new offer. So company A makes a job offer to employee B. Employee B makes a counter offer. In other words, employee B rejects the offer from company A and makes an offer to company A. So the counter offer is a new offer. Is a new offer that was preceded by the rejection of the original offer. And why is this important? Well, I know in real life it's usually not like this, but legally speaking, when you make a counter offer, because you have rejected the original offer, the person or the company who made the first offer, they may decide not to accept your counter offer, and then you cannot, legally speaking, you cannot change your mind. You say, no, okay, so now I change your mind. I will accept your original offer then. But that offer was already rejected. So you cannot accept an offer that was rejected already. Because an offer that is rejected is ended. This offer is ended. One way of an offer being ended is by rejecting it. So this is very important. I know, again, in real life, we get a job offer, we make a counter offer because we want to change some terms. Could be salary, could be vacation, could be benefits. But legally speaking, when you change the terms of the offer while accepting it, you are actually rejecting the original offer and making another offer. Okay, so keep that in mind. And then once the contract is formed, even though you have not started working yet, if any of the parties wants to breach the agreement, they do not want to start working, the employee does not want to start working, or the company doesn't want to offer the work anymore, we will have, there will be a requirement for the notice or pay in lieu of notice. And this is, we discussed this in chapter 2, if I'm not mistaken, the anticipatory bridge. So the anticipatory bridge takes place when a contract is already formed, which is the case here, offer accepted, and there's consideration, but one of the parties informs the other that they will not go ahead or move forward complying with their obligation. So an anticipatory breach would take place. Okay, so those are the main details here for the contract. What is the consideration in an employment agreement? Well, the benefit for the employee is to get wage or salary benefits, and the benefit for the employer is to get the service, the expertise, the experience, loyalty from the employee. So both parties benefit. Both parties derive a benefit from the contract. That's why we say consideration is there. What are some advantages of a written contract? Well, first of all, the risk for misunderstandings is reduced. Any potential conflicts can be addressed at start. So usually employees, they are in doubt about some sections, about some clauses, so they have the opportunity to ask that prospective employer what those mean. They can also consult with a lawyer to eventually address those conflicts. And it all leads to less uncertainty. Again, verbal contracts are as valid as written ones, but if you need to rely on a verbal agreement to enforce your rights, could be the employer or the employee, you may forget some of the details. You may forget some of the terms because it's not in writing. Maybe it was the supervisor or it was someone else who entered into an agreement with that employee, and that person is not there anymore, is not working for the company. So you don't know the main terms. And there's also the fact that we'll see in the future common law dismissal or common law notice. The employer will be in a higher risk to pay more as either severance pay or the required notice. Okay, so it's highly recommended to have contracts in writing. And some of the structure actually of the employment agreement is usually you can vary the form, but usually it deals with names, so employer and employee, the job title, brief description of the job title, of the position, sorry, and the reporting relationships. And if those changes, if these details change, you may want to have these in a schedule, not the main part of the agreement, but you can have Schedule A, Schedule B, like an appendix, because you can modify, you can update this, you can update the job title, the job description as the employee progresses within the company. So some companies will do this. What the start date is and the end date, if it is a fixed term agreement, if it is for an indeterminate period of time, then there's no end date. What the rate or salary is, or what the wage is, when it is paid, other terms related to hours of work, benefits, when the employee is entitled to benefits, usually after probation, any required notice, any reference to collective agreements, if applicable, who owns the inventions, so everything that is created in the course of employment, who owns it, and policies, what policies apply to that agreement, where the employee will work, so addresses for location or locations. If there are any time frames for salary review, eventually restrictive covenants. The restrictions we saw: non-competition, confidentiality, and non-solicitation. So those are some topics for the employment contract. And at the end of the textbook, you have an example, you have a template of an employment contract just for your reference. Eventually, if you have yours with you, if you have a copy of yours with you, you can also check and understand it a bit more, learn a bit more about the terms, about your rights, and also about your obligations. So terms, they may be implied or express. So express terms are those that are in the employment agreement, are those that are written, that are spelled out in the employment agreement. And they are usually specific for a point in time. What point in time? The moment you are hired, because they may make us interpret those terms in a different way as time goes by. They may. So, for example, there are some issues that may take place during the employment relationship that the terms, the express terms there, are not updated or are not correct to be there anymore. If this is the case, and this is something that is related to obsolence, so that's why you should be reviewing employment agreements on a yearly basis, every 2 years, because you don't want an old agreement, someone who has already progressed, is in a different job position, has other duties and responsibilities, but their employment agreement has not been updated. So it's very important to keep employment agreements updated. So making the express terms as more updated as possible in time, because whenever you are using them, they are mostly reflecting that moment in time. Implied terms, we have implied terms later on. So keeping on the express obligations or express terms. So the obligations, they are usually clearly expressed in the agreement. And when this is the case, and this is highly recommended, but not only recommended, but this is the best way for employers to have their employment agreements enforced by the courts literally. So courts usually, they do not construct a different interpretation, a different understanding for contracts in general. And this also applies for employment agreement. So the more you make the obligations in the employment contract express terms, in other words, clear terms, detailed terms, spelled out terms, the better you will be as an employer when courts need to enforce those terms, because they will most likely interpret them literally, enforce them literally. Sometimes courts will interpret the language contrary to the interest of the dominant party. So if they understand that the literal interpretation cannot be applied, then they may interpret contrary to the interest of the dominant party. The dominant party is usually the employer, not only because the employer is financially stronger, but also because the employer was the one drafting the agreement. The employer was the one probably having legal advice to draft that agreement. And also, if the terms are extremely one-sided, courts may even go as far as declaring those terms void or null. So if they are extremely one-sided, let me give you an example here. Let's say the company says the required notice, the dismissal notice is as per the Employment Standards Act, minimum 2 weeks. But they also say that for the employee to resign, the employee has to give a 60-day, 90-day notice. So this is extremely one-sided because they are going to give the minimum notice to dismiss the employee, but if the employee wants to leave the company, resign, the employee has to give a 2-month notice or 3-month notice. So this is an example of a clause of terms that would probably be considered to be extremely one-sided, hence a void term. And also when the obligations, the interpretation for obligations is ambiguous, then the court may rely on other evidence, on outside evidence, extrinsic evidence. So, for example, how that industry interprets that obligation, or how the company has interpreted throughout time. So they may use. But the main lesson here is that courts, judges, they do not like to rewrite the agreement. They prefer to interpret the way it is. So I'm telling this because the more clearer the terms are, mainly the obligations, the better it is for the company, because courts will probably have the opportunity to interpret them the way they are written, in a literal way. So the company would not be surprised with a different interpretation or a negative outcome for them. The implied terms. So implied terms are terms that may not be there, may not be expressly written, spelled out in the contract, but they still apply. So this is part of legislation, this is part of customs of practice. So those are terms that are in all employment agreements, even though they are not written there. So, for example, most of the obligations owed to the employee, they are not written in the employment agreement, but still the employee has to be loyal, the employee has to be a trustworthy employee. The employee cannot be disclosing confidential information if the employee has a managerial or is a supervisor, for example. So those are obligations that are common sense in all employment relationships. So those are implied obligations, implied terms. Even though they are not spelled out, they still exist, they still apply. Okay? So as I said here, they are usually oral, they are related to the factual intentions of both employer and employee, and they are also related to past practices, pre-contractual negotiation, customs, and common sense, as I said. So the common contractual terms, they may be always used, but the best way for companies to use an employment agreement or to have an employment agreement is to customize. You can have a main template with the main legal terms. However, companies will be better off if they customize as much as possible for their employees, so that they really address the need for that employee, for that job position, for that job title, etc. So customization is important um, in terms of legality, in terms of enforceability of contracts. Um, Also, the key terms that are in the letter of hire or in the job offer, uh, they could also be incorporated in the employer's policy manuals. So they should also be used uh, in a way that the job offer and the employment agreement and the policy manuals are all in harmony. They are not contradicting one another. The key terms I've already mentioned to you, and the more senior or specialized the job is, the more customized should the contract be. So it's highly advisable to customize contracts for more senior or specialized positions or jobs, such as senior executives, directors. It is important to have a more customized employment agreement because obligations, rights of both parties, they may differ due to the importance of the position. So now let's look at some terms and let's discuss some of them. So the job description, you should describe in terms of the role and the responsibility. So usually you would describe using verbs. So designing, interacting, reviewing, making reports, setting up. So you should include several verbs, several actions that the employee will perform. Remuneration could be salary, could be the wage, could also be bonus, could be uh, stock options. So this could all fall here under remuneration. The term of the employment, is it a fixed employment? Is it a fixed term job or is it indefinite? So if it is fixed, then there's no need for a notice to dismiss the employee because the term is fixed. However, if it is indefinite, then uh, the Employment Standards Act will apply in a required there is a required notice to dismiss an employee. So that is important there. The termination clause. So the notice terms, they are only valid if they are express. So here, very, very important. I told you that express terms are those in the written contract, are those spelled out. So a company who hires under verbal agreements will have a real hard time to prove that the notice term is express. And if the notice term is not express, then the common law reasonable notice will apply. We will see what the common law reasonable notice is in the future, but keep that in mind. It is very important to have a written agreement and also make it express, make the notice terms express. So the required notice to dismiss, but also the required notice if it applies for the employee to resign. Only valid if expressed. So this is very, very important. And in this termination clause, the company may also deal with the method of payment. So when the payment will be made, how will be made after termination. As I said, may include the notice of resignation, very important for more important positions, more senior roles that are difficult to fill because it requires the company more time to hire a replacement. You can also deal with just cause for dismissal in this clause, and the duty to mitigate. This duty to mitigate is a contract law requirement. So whenever a contract is breached, and whenever we are victims of a breach of contract, we have a duty to mitigate our loss. So for an employment agreement, for example, if the employer breaches the agreement, the employee has a duty to mitigate their loss. The employee needs to update their resume, needs to start applying for other jobs, try doing something to mitigate their loss. It doesn't mean the employee has to get another job. No, if they do get another job, it's even better. But they have to show, if required, in a court that they did everything they could to attempt to mitigate their losses. So this is an important clause, and if this clause is in the employment agreement, it will be usually in the termination clause. Probation period. So probation period is that moment to test the employee, but it's also that moment that the employee is testing the company, whether the employee is happy with the company. So it's a testing for both sides. And a probation is only valid if specified in the contract. So again here, the importance of a written contract. How can you prove you specify to the employee the probation period if it is a verbal agreement? It is very difficult to prove. So it's not impossible, but it's very difficult to prove. So again, the importance of a written agreement. And one other aspect here, a probation is only valid for 3 months. Well, actually, there can be a probation for 6 months, for 1 year. It is fine. It is almost fine. Because after 3 months, there has to be a notice to dismiss. So what I'm trying to say here is that even if probation is longer than 3 months, the employee can only be dismissed without the required notice up to 3 months. If after 3 months, even if the clause is saying no, probation is for 6 months, but the law says that after 3 months, a notice is required. So keep that in mind. The name probation in your employment agreement is irrelevant if you are there for more than 3 months. And I'm talking about an employment agreement. I'm not talking about a collective agreement in which negotiations are different. Okay? And the law surrounding a collective agreement is also different. I'm talking here about the Employment Standards Act for provincially regulated employees. Up to 3 months, no notice required to dismiss an employee, as long as there was an express term in the contract about the probationary period. Okay, so that is very important. If you believe there may be relocation for the employee, so you should also address this. If the employee will be reimbursed by costs, if employee will get a relocation bonus or amount, if the employee has the right to refuse, etc. So you should address this here. Benefits, what benefits the employee will be entitled, and when will the employee start accruing those benefits. Usually, employees are entitled to benefits after the probationary period or after 1 year or after 6 months. So you should address all those here in this clause. The restrictive covenant, so we have discussed about this already, the restrictions for non-disclosure, non-solicitation, non-compete. Remember, they have to be reasonable in the time limitation and also geographic limitation. And they have to be express terms here as well. Yeah, express, and they are valid during employment and also after employment agreement. Remember that it is void. This clause, the restrictive covenant, they are void if the employee was wrongfully dismissed. So we also discussed this in chapter 2. I won't be detailing here much more, but you can read. If there are doubts about the validity of those restrictive covenants, the burden of proof or the onus to prove the validity is on the employer. So, and any doubts will be resolved in favor of the employee. So my question here is, when we are in the classroom, I usually ask the students, so you get the draft of your employment agreement. So you're starting a new job next Monday, and they send you the draft of an employment agreement. And as per your understanding, the restrictive covenants there, they are not reasonable with regards to duration and geographic location. So because you're taking this course, you tell yourself, well, they are not reasonable. In principle, they are not valid. So what you do? You could say, well, I would write back to the employer and say, or prospective employer and say, hey, this clause does not seem to be valid because the restrictions are not reasonable. This is not legal advice, this is not recommendation, but I would say this would not be the best approach. I would be in silence, I wouldn't say anything, I would sign the agreement, because in case the employer wants to enforce this clause, they would need to prove the validity. And certainly they were the ones checking with lawyers, employment specialists to draft this clause. So I would not touch upon this. I would just leave the way it is. And when I left the company, if I were to work for a competitor and I were sued by this former employer, I would then challenge the validity of that clause in court. And the employer would be the one to prove the validity, in charge of proving validity. So as an employee, I would be silenced. As an employer, my our lesson here is draft restrictive covenants as best as possible, because all doubts will be resolved in favor of the employee. So we have to be very cautious drafting those clauses. And again, as I said, a valid restrictive covenant, they, even if they are valid, valid, they are reasonable time, they are reasonable in geographic location, they are protecting the legitimate interest of the employer, but the employee was wrongfully dismissed, that valid restrictive covenant will cease to bind the employee. So the employee will not be bound by that clause anymore. So managers of all sections, of all departments of companies, they need to know this. Let's see, you're working for a tech company and they do a very good job protecting trade secrets, everything they are creating. They have a well-drafted restrictive covenants for all employees, for scientists, for researchers, etc. But one of the manager just got mad with an employee, with a scientist, and wrongfully dismisses that employee. So imagine the risk for the company that that scientist can use can work for competitors right away, can use confidential information they had access to, etc. So that's very, very important to keep in mind this. Well, non-competition, continuing. Intellectual property ownership. So who owns the work? If nothing is detailed in the employment agreement, so if parties decided not to address this issue, and so it means parties are in silence, in principle, it is the employer who will own the inventions. And why? Because the employee is creating in the course of employment. The employee is creating using the employer's resources, and the employee is being paid wage, salary to create. So it's part of the job duties. So this applies when parties are in silence, when parties did not address this issue in the employment agreement. Tech companies, they usually make employees to assign all the inventions. So they make it express in the employment agreements. Everything that is created in the course of employment is automatically assigned to the company. And freelancers, well, freelancers are not in an employment relationship. So usually freelancers, they negotiate their job or work contract, their service, in a way that they retain the ownership. They retain the rights for ownership. Can an employee negotiate the employment agreement in the way that they retain ownership of inventions? Yes, they may. If the company accepts, it's fine. But the employee will only own in case it is clearly expressed in the employment agreement. If it is not there, as I said, the general rule is that the employer will be the one owning the inventions. Parties may also choose the jurisdiction, the place where disputes will be dealt with, also the law applicable for the employment agreement, even though there's very little room here for parties to choose. Because employment legislation is usually there to protect employees. So in most cases, courts, they want the place where the employee performs their job, so local laws to apply. So even though the company has their headquarters in Alberta, but you work here, you were hired to work here in BC, so the BC Employment Standards Act will apply. If you have any complaints, you will file a complaint with the BC labor branch, employment branch, or if you want to sue, you will use the BC courts. So there's very little room here to choose a different place and even a different law that is not related to the place where the employee performs the job. Okay. Corporate policies. So it is important to mention that the employee is also bound by all policies that are valid, and that those policies may be modified from time to time because they may be updated. And it is also important to give a copy of all those policies to the employee before they sign the employment agreement. In other words, how can an employee agree with the policies by signing the employment agreement if they were not given a copy of them before signing the contract? So that's a big issue there. So make sure when you send a draft agreement for the employee to sign, the future employee to sign, you also send copies of all policies that are applicable to the company. A more legal clause is this entire agreement clause. This means that everything that was discussed before, even uh, the job offer, the interview, so everything from the past is left there. Everything that was discussed before the employment agreement will not be considered. So companies usually do this because they want to avoid risks associated with the interview, associated with issues on the offer that may differ from the employment agreement, etc. So it's a very legal clause. Employers do this in their employment agreement to protect the company. The inducement or allurement or enticement clause. So this will only be there in case actually the employer offered too much. The employer actually induced the employee to join their company. So if this was the case, which is fine, but the employer should use this clause to eventually recognize the employee's former employer's notice in a way that the employee could have a secure job, a long-term job, and now because of the inducement is interested in joining the company. So the new employer should provide more benefits, should provide a longer termination notice. Remember, we saw in chapter 2 as well, if I'm not mistaken, a case in which the required notice because of inducement was over 1 year. The employee moved provinces. So it's important to address this issue in case the employee was hired based on inducement or any alert, any two advantages offer for the employee to join. Another legal clause, the independent legal advice. So good employment contracts, they will always have this independent legal advice. It is a clause in which the employee is representing and declaring the employee had enough time to seek independent legal advice. In other words, the employer is trying to avoid risks associated with uh, one-sided clauses or clauses that are too much favoring the employer itself. It will be used by the court. It will be claimed by the employer in case the employee alleges that they did not have time to review, etc. So good or well-drafted employment agreements will usually contain this clause. And when one thing is important here is that not only the clause is the clause important, but you also need to use this clause along with time. So if the job is starting tomorrow and you send the draft to be reviewed and signed today, so even though you have the independent legal clause in the employment agreement, there was no time, not enough time for the future employee, the prospective employee, to send the draft to for legal review, their independent legal reviewer. So it is important to also take into consideration that the employee needs to have ample time or at least sufficient time to have the employment agreement reviewed. Then such clause will play a more important role in case the agreement is challenged in court. Severability clause, also a legal clause, a purely legal clause. When it is present, it is asserting, it is telling us that if one part of the agreement, one section, one paragraph is considered void by the court, the employment agreement as a whole will still stand. That will not affect the validity of the remainder of the agreement. So that's a legal clause aiming at keeping the whole agreement valid in case any part or any parts are considered illegal in court. For more senior, for more executive roles, there's this golden parachute clause, or it's called golden parachute clause, and this one is related to bringing additional benefits to the employee in a way that the employee offers not to be distracted, offers not to be looking at other interests that are not those that pertain to the company, pertain to the employer. So instead of the employee looking at their personal interests in some moments where companies are, let's say, going through mergers or companies are downsizing, etc., because the employee, that senior employee, that executive employee has a golden parachute clause, it means the employee was given extra benefits, additional benefits. So the how do I say this? The counter giving. So the employee will give in return for the company their full attention to the company's interests instead of their own personal interests. The implied duty to maintain confidentiality. So we saw there are the restrictive covenants. So confidentiality clause, non-disclosure, but also any employee in a company who has access to confidential information, they have the implied duty to maintain confidentiality. They cannot disclose freely. So this is an implied duty. And on the top of this implied duty, companies also use the restrictive covenant to further state and ascertain and be sure that the employee will not disclose their confidential information. So let's look at now the enforceability and interpretation of contracts, mostly of written contracts. So first part we are looking at is issues related to consideration. Again, I told you in the beginning that consideration is related to the benefits that both parties need to derive from the contract. Or we can also understand consideration as the price of the contract, the price to be paid. So when I'm working, my price is to give my time, my expertise, my knowledge, whereas the price for the employer is to pay me the wage or salary, benefits, etc. So that's consideration. And contracts that lack consideration, contracts that no parties derive a benefit or only one party derive a benefit, they are not enforceable in courts. So we say the contract lacks consideration. So when one party promises something to the other, so I promise to give my friend a ride to the airport, I'm not entering into a service agreement in which my friend will pay me and I will drive my friend to the airport. So if I just promise, if I just offer to freely drive my friend to the airport, this is an example of a gratuitous promise. This is an example of a contract which lacks consideration. So this is very important. And we'll see some examples now, some situations in which both the employee and the employer may be in trouble. They may be relying on a contract that actually is not enforceable because it was originally lacking consideration. So the first case we see here is Francis versus Canadian Imperial Bank of Commerce. So this case teaches us that when an employee begins work before the contract is finalized, in other words, before the contract is signed, it means that when the employee actually signs the agreement, that agreement will only be enforceable if there is new consideration, if there is a new benefit. So in other words, if the employee starts working before signing the contract, it means both the employer and employee are in a verbal agreement, because the employee knows they have to start working, let's say tomorrow at 9 a.m., etc. They will do this, and that, but they haven't signed the agreement yet. They have read, eventually they read the draft, they read the job offer, and they start working before signing the agreement. So it means a verbal agreement is in place, and for a written agreement to be enforceable, a new consideration is required, a new benefit is required. So a good idea here, and again, it's not legal advice, not recommendation, but a good idea here, in case this happens in real life, the company should give the employee half a day off or 1 day off, just to give the employee a benefit in exchange of the benefit for signed written agreement. So that is very, very important here. The lesson we get from this case is very important. We also have ASM corrosion control versus George. So here, whenever the employer wants to add a new term to the contract, so let's say from now on, the employee will limit a benefit, or they will change how benefits or how vacation will be accrued. So they want to change any term of the employment agreement, or even if they want to update the employment agreement. This modification will only be enforceable if the employer offers a new benefit, offers fresh consideration. Because if only the employer is getting a benefit, in other words, having the modified terms inserted in the agreement, and the employee is not getting anything in exchange for this, it means that amended employment agreement lacks consideration, is not enforceable. What this case further tells us is that the employer can do this, can incorporate, let's say, a document, a policy, for example, without offering new consideration, without fresh consideration, in case the employment agreement is clear that policies will be amended from time to time to reflect changes in the company, etc. Employees will be given time to think about the changes in the manuals. Employees will sign a receipt that they received, the new policies, the new manuals, and the employees will be also given a chance to ask questions, be trained, or learn about the changes. So in those specific circumstances, new consideration, fresh consideration is not required. But again, remember that the employment agreement itself needs to contain clear language that manuals, uh, policies, they may be amended from time to time by the company. And also, whenever there's an amendment to those, the employee needs to be given a copy, time to review, and the employee should also sign a type of receipt form or receipt that they received it. So here it falls into an exception. The general rule is that whenever an agreement needs to be changed, modified, both parties need to derive a benefit. In other words, there has to be fresh consideration, new consideration. Uh, in terms of interpreting the contract, it is usually the case that the parties, they are unequal in their bargaining power. Yes, usually the employer has a stronger bargaining power because of their position. So the employer should take this into consideration while they are drafting the agreement in a way that they offer reasonable contract terms. They avoid as much as possible the one-sided terms, the one-sided expressions. Also, they give the candidate time to review and obtain independent legal advice. And they expressly refer about this opportunity in the agreement, as we saw. And also they give the candidate um, an opportunity to ask questions, doubts about the terms, about major terms, and it is also important, it may be important to have the candidate initial some major terms in a way that you have evidence those major terms were brought to the attention of the employee. So those are actually good practices based on the inequality of bargaining power between employer and employee, and avoiding the courts to consider that the employer made use of their dominant bargaining position and exercised undue pressure on the employee. So those are ways to prevent this in the employment agreement. Obsolence. So I'm not sure I'm pronouncing this correctly again, but I think so. Obsolence. What does this mean? So it means that the terms, they do not reflect the employee's position anymore. Well, the employee, let's say, was hired as a secretary, but has worked so well that after some years, some months or some years, the employee has become the office manager, for example. So you have to make sure you periodically review uh, the agreements, the employment agreements, and make any updates that may be required. So if the employee is now involved with other duties, other responsibilities, but remember, when you are updating the agreement, you have to offer a new consideration, a new benefit. So the good thing here is, or a good opportunity is, if you are promoting the employee, it you are probably giving paying more to the employee, giving a rise, a salary raise. Sorry, a salary raise. So you are giving a benefit. You should take this advantage to also update the terms, because you would be giving fresh considerations. I think, yeah, that's the second bullet point here. Make promotions conditional on signing an updated agreement. So this is very important. Maybe an yearly review for employment agreements. You could also set the minimum and maximum notice provisions that apply regardless of the changes in the jobs. Or you can just refer to the Employment Standard Act in a way that both the employee and the employer, mostly the employer, is required to provide the minimum notice as per the Employment Standards Act. So you can use this. Because let's say if politicians are changing the legislation, if you refer the legislation in the employment agreement, you don't need to be updating this part because you did not use the law at that time. So you gave the employment agreement an opportunity to keep updated, to be updated, because you are referring the legislation itself. So if the legislation changes, this change automatically applies to the employment agreement. So if employers fail to meet the minimum statutory standards, then those clauses, those sections, they will be unenforceable. They will be null. They will be void. And one important aspect here is related to the notice, is related to the required notice to dismiss. So the minimum notice is 2 weeks, and then after 1 year, 3 weeks, and then it goes on increasing. So if you just sat there 1 week, or if you sat 2 weeks, regardless of the length of service of the employee, that clause may be below the minimum standards from the Employment Standards Act, and then that clause will be void. And when that clause is void, the employer will be liable for the full common law reasonable notice. So that is important. And it is also a good practice. Courts, they usually want employers to give a little bit more than the minimum standards for the notice. So this is the case here, Matchinger versus HOJ Industries. So not only must the notice comply with the minimum employment standards legislation, but it has also to be drafted carefully. So it has to be clear. And if you give a bit more, so 1 more week or double the time, and I know it's cost for the company, but you may be avoiding risks to be sued and be liable for the common law notice. Use of ambiguous language. So this we saw already. Whenever there's ambiguity, doubt, the contract will be that doubt or that section, that expression, that term will be interpreted in favor of the party that did not draft the agreement. And it is usually the employee. So for ambiguity, the contra pro frentem rule will determine that courts interpret that in favor of the employee. Okay, so it's important to avoid ambiguous language, to review as much as possible, to be objective, clear, and plain in the language of the contract. So to end, just some tips on written employment agreements. Using clear language, be fair during the negotiation, give the employee time to read, understand, and seek legal advice. At least meet, but preferably exceed the minimum statutory standards. bring the major terms, the critical terms to the employee attention, eventually have them initial beside those major terms, provide additional consideration, additional benefit if the new terms will be included in the contract after it was signed or after the employment begins. So again, fresh consideration, a new benefit is required for an amendment, for a modification of the employment agreement. And use customized contracts as much as possible, avoiding standard templates, standard forms that may not tell or may not be in favor of the company in case it is argued in court, it is challenged in court. So I know it's long, it was a bit longer chapter, but there would be even many more details to share, but I believe I have shared the main details and aspects related to the employment contract. Thank you. Bye now.